It's the 29th of October 2022, and you're very welcome back to Real True Education, Not Fake News. And I want to do one video without any hold-ups or prompts or any type of cues or that, to try to clarify the very important case of 2419. Now, I've made videos number 13 and number 45, and particularly 45I, on this very case. And unfortunately, last May, I was coming out of my second bout of COVID-19. And as a result, my voice, one of the things it did to me was it made my voice a bit rough. And it's hard to hear me. It's hard to hear what I'm saying. So I'm going to go over it once more with you so that I can give people a simple explanation. Now, I may post underneath here what videos are relevant already, but this is the story. When the EU was being conceived and in the process of getting various countries to go along with it and join it, and in the case of Ireland, we needed a referendum because of the unique nature of our constitution. We had to vote on it several times. And there are two documents that's important. One is the Treaty on the Functioning of the EU, and the other one is the Lisbon Treaty. And both of these documents, both of these treaties, which were the groundwork for the various campaigns to extend and to get countries to join the EU, both of these documents contained provisions on numerous things, including justice, including lots of stuff. Trade, single market and everything. But there was a section to do with the environment in which it recognized that a good environment was essential for the well-being of the people. And it gave certain guarantees both in the Treaty on the Functioning of the European Union and on the Lisbon Treaty. Okay, so folks, again, this is number 50. I'm moving ahead to get a nice round figure, so this one can be just 50. I'll do nothing else on 50 except this court case. And it's not for windmills or anything else. This applies to all over. Now, I must say at this point that anyone can use what I'm giving them here, and I don't have control of the lawyers or the judge or anybody else, and I have to issue a disclaimer that I cannot take responsibility for the information I'm giving here. That's for your lawyers or whatever to do, and that's for a course for study. I cannot take responsibility or be liable for how this is implemented, and in most cases, to get your rights in this, it may be necessary to go all the way right up to the European Court of Justice. So I cannot take accountability. That doesn't mean that you shouldn't listen to this. This is how I put it across to you, because people who are facing things like wind farms, pylons and all that need to know this. If you don't know this, you're not at the races. So when the EU got up and running, it then went along about to set up directives and regulations for the environment, as it did for other things like the single market and all the rest. We're only dealing with the environment. The first thing was the EIA, the Environmental Impact Assessment Directive, for local projects, implemented in 1985 and then updated and improved and repealed and replaced in 2011 and 2014. That's all right, it did that. That's the local project. Then it did the SEA Directive, the Strategic Environmental Assessment Directive 201/41 EC, which became law in Ireland in 2004 by virtue of 436 and 437 statutory instruments of 2004. Okay, so it delivered on its promise. It also had one on pollution control. It had one on habitats. Okay, it had all those. We're just dealing here now with the EIA directive, the local assessment of the local quarry or the local railroad or the local wind farm or whatever it is that needs an EIA for the ground it's on. You have to get it passed, show all the environmental impacts of what you're going to planning to do. When you get that done, you then submit your planning application, which includes in Ireland under the Planning Development Act an application for planning permission. And if the planning authorities then look through the EIA and decide it's acceptable it won't be too severe on the environment, they can then grant or refuse it as the case may be under the Planning and Development Act. Enough said there. We now move to the overarching public planner programme. The overarching public planner programme, and there's a list of them in the SCA directive, and their energy is included. There's also town and country planning, agriculture, fisheries, river basin management, town, and various other things. The main point here for people facing energy stuff and wind farms is energy is very clearly included. There's another category then that there must be an SCA done if it has a significant impact on the environment, and because that's subjective, you're in trouble if you go to plead that, because how do you prove it has a significant impact? Whereas with energy specifically written in. So all public plans and programs in each member state must be assessed under Article 3.2, and an environmental report must be prepared. The directive also states about what it must be, how it must be done, and what must be covered. But we'll just stick with we'll keep it simple. So if it were to be complied with, public plan or programme must be assessed under Article 3.2 from an engineering point of view, but more or less from the environmental point of view. And it must produce an environmental report, a piece of paper like this, an environmental report written at the top, and it must be signed off by somebody who's qualified to do so on the bottom. And that environmental report includes the need for the project and all the rest of it, and its impact on the environment. The need for the public planner programme. So the National Renewable Energy Action Plan should have been properly assessed in this way, as we're not going to whether it was or not. But what I can tell you without a shadow of a doubt, admitted to me in court, I will make an affidavit to that effect, by EirGrid, is that there is no environmental impact assessment for onshore wind in the Republic of Ireland. That's agreed and admitted. If there's ever a problem proving that, I'd be prepared to take the oath and swear it and make an affidavit. Okay, so that's the first thing. So it's accepted there's no SCA for onshore wind. They never assessed it. Now the problem then is, how do you get that? I've been trying to get that done. Pat Swords, my colleague, a friend, took a case. It didn't work out. I took a case on the North-South Interconnector, and that didn't work out. So it became very clear that if you were to push this, you had to take a different approach. You had to work a more clever approach to it. And so we have a case, Pat Swords, whom I'm helping him with. We have a case for I think it's the Netherlands and Sweden. Sweden anyway, the Netherlands is in there as well, and Ireland, a group from Ireland are in there also, and we have a case to stop the European Investment Bank granting monies for energy infrastructure in the EU until they carry out the assessment under the Strategic Environmental Assessment Directive. So the idea is you have the overall arching plan assessed, and then you do the projects underneath that as individual parts of it, and then you have the Planning and Development Act, and which is the vehicle to do it on, right? And that's as best as I can explain that. So we had great trouble and we never succeeded. Most lawyers told us that this is nonsense, it doesn't apply, it's soft law, it's a load of nonsense, in which case the whole premise of the EU and the way it's founded was a scam. So that didn't seem right. I've had lawyers, I've had smart people tell me it's soft law, you needn't be trying it. But anyway, so we struggled on, and in 2019, a group in Belgium challenged a wind farm of 5 wind turbines, but they put in a ground that none of us actually saw, and we should have perhaps seen it, and even I should have seen it too. And that was that all wind farm applications in the EU will be aided and helped by a guideline or a circular or some type of a document to guide the planner on the installation of wind farms. So in Ireland, that's the Wind Energy Guidelines 2006, and in various areas of Holland, it's split up into different areas. The local authority did the guidelines over there, and they're very like our own. They tell you how far back they should be from dwellings, they tell you what shadow flicker is, how they should be painted, They give you the various things about distance and all that sort of stuff, and noise, shutter flicker and all that. Interesting enough, uh, uh, um, um, they don't they don't they don't deal with what good these windmills do. It's just a guide for the planners. But the group in Belgium, when their wind farm was granted in the Flanders area of Belgium, it's a Walloon, Terra Walloon area of Belgium, they challenged on the grounds that the Wind Energy Guidelines 2006, there were guidelines issued in every EU state, and they all seem to be issued in 2006, so there must have been a bit of a cooperation there or corroboration. But they challenged and they said these guidelines were never assessed on the SCA directive. They were never assessed under the SCA directive. And the Belgian government fought them, as they normally would, and it went to the local court in Belgium, and the local court sent it to the European Court of Justice, and it went to the Grand Chamber, which is the highest part of that. There's an Advocate General who prepares the case and gives an opinion, and then the court rules on it, right? So the ruling of the court in 2419, which didn't come out until 2020 or a little later, but it's 24 of 2019, which means it's the number 24 of that year. So what the court ruled unanimously was that the guidelines are a part of the public planner program if they're used by the planning authorities to guide them in their decision. And because that's the case, because that's true, therefore that's a no-brainer. They said it is, that they are in Belgium, they're used by the planning authority, they have weight of law, they have persuasive weight, and in Ireland and everywhere else they also have. So as long as it's not issued by some, like the brass band or something, some other crowd or friends of the earth, if it's issued by them, it has no weight. But if it's issued by somebody that has government approval and is used by the planning authorities, then bingo, it's covered. So they said it is a planner program when you create these guidelines, and hence this applies all over the EU. The next question then is what happens this particular wind farm in Belgium, and the ruling of the court was it must be refused permission, it must be annulled, it must be quashed. No way about it. Back to the board, folks, and create your new guidelines. And of course, that's a big trouble all over, because the wind farms are already up and the governments are up the wall on how to deal with this. Now, people always say to me, oh, sure, they'll change it, they'll change it. They can't change it because it's built into the EU, into the treaties, that subsidiarity applies. It is not the case that Ireland or Belgium can tell the EU what to do. It's the other way around. The sources of Irish law are European law, the Irish Constitution, the Statute Law of England, the Common Law of England, the Statute Law of Ireland, law before the formation of the state, which is English law, and stuff like the Medical Association and all that. So again, one, EU law is tops, Irish law is second. There's a procedural matter called the Common Law of England, which still applies here, and then there's the Statute Law of Ireland, like the Road Traffic Act, or we'll say any act you wanted, the Foreshore Act, for example, the Planning and Development Act. So that's the rule. The Europeans on the top, so they cannot change it. And anyway, it's part of the treaties of the EU. So because it's part of the treaties of the EU, if you changed any of it, or took out the directives, or changed them, you'd have to unravel the whole EU. That's nearly impossible to do. Moreover, there's an awful lot of case law now built on these directives, so it can't be changed. Okay, now, so that settles that. So the next thing then is it ruled that the application for the windmill has to be quashed. And I immediately seized on that and got groups to use this in any judicial review. What is said is there may be groups that don't have the money to do this, but if they have, include the 2419 case in their statement of grounds. And this happened in one case that I had a say in, and it happened in a case down in Cork, Gugambara, which I didn't directly have a say in, but we were in touch with the group down there to make sure it was in. So any judicial review on a wind farm that doesn't include a ground on 2419 is seriously defective, because they're getting their EIAs on their application better all the time. They're improving it all the time. Okay, so the next question that was put to the European Court of Justice, folks, put to the European Court of Justice was what happens to existing wind farms that are built under the 2006 guidelines, in other words, after 2006. If the planning application was based on the 2006 guidelines of any country or any guidelines from that country, and they're not in line with the law, and the court has already ruled that they're not assessed, there has been no SCA assessment, no public participation, no right to take a judicial review, nothing. Just made up by somebody in an office having the biscuits. So what happens? What happens in that case? And the European Court of Justice has ruled the wind farm application has to be annulled. It has to be quashed. Even now, even though there could be up 10 years. That's what it ruled. And then it put in a rider to it, or a little sideline that they will allow, it can be allowed, if the local court law, the country has the law to do it, to keep them in there for long enough to get a replacement, provided you're going to have blackouts. So if let's say somebody took an action in Ireland to take down all of the wind farms in Ireland, the whole lot of them, 44,000 megawatts, it could be argued that there might be some problem with supply. They might have to get a new coal-fired power station. So, but it's only for as long as it takes, and that has to be very short. It has to be a short, strictly short period. Now, if anyone takes an application on a wind farm not built, clearly that doesn't apply because it's not being used. If you take an application on one that is built, well then if for example my local one or some other one, well then they can't very well plead that the lights are going to go out if it's shut down. So it's not a problem. But even they can only do that for as long as it takes to install a diesel generator or do something else somewhere else and get planning permission for something else. So essentially it doesn't matter. The key is any new application that's done on the 2006 guidelines must be quashed. End of story. Back to the drawing board. And that has happened in 2 cases already. And what's happening is groups put in another ground, some other old thing like a white frog or a brown rat or a donkey sanctuary or some other thing like that, or the road widening or something like that, or a river, something which might not work normally. One of them was that they're not properly described, and Judge Humphreys did say they're the biggest structures in Ireland, they have to be properly described. But now they're getting over that, they're doing it, they're naming the model of the wind farm, wind turbine, and therefore they're getting over that. So really you're down to putting in, what's done as a strategy is to put in 1 or 2 other old grounds, could be something else. And rather than go in and contest 2419 with the risk of losing and shutting down the whole project and being sued to high heaven by the likes of myself, the strategy of Bord Pleanála appears to be, this is my opinion, I'm not prepared to say this will happen in every case, this is what's happened so far. So again, I make the point, you want to study this, you can't just come suing me because it doesn't work out. But what they do is they put in another ground or 2, and Bord Pleanála will agree and concede on the other ground, rather than allow 2419 be contested in the court. But at some stage, hopefully, we'll have a statement of grounds which will include nothing, only 2419, and then they either fight it or they give up. And if they give up, they set a precedent. Now remember, in the civil courts, unless there's a trial, you do not have a precedent. If 500,000 people went into the High Court on a civil case and it was settled in every case, no principle is set. It's only when when it goes to trial and the judge makes a ruling that you have a precedent. Only then. So what happens then is that they might fight 2419, and for that reason, a judge in this High Court that rules against you on that, he's ruling against the European Court of Justice. If they do, you'd have to go to the Supreme Court, and they're mostly mature judges who have no further career or ambitions or anything like that, and they would almost have to side with the European Court or refer to the European Court of Justice. That may happen yet. So a bit of money is needed, and the problem for me as a lay litigant is I can go to the Irish Court, the Supreme Court, but I can't go to the European Court of Justice without being a lawyer. And so that is the problem. Okay, we might look at that at some stage, but I'm waiting until more precedents are set, until it becomes apparent there could come cases everywhere, somewhere else. Now, in the Netherlands, since 2419, see 2419 is its proper title, in the Netherlands, a similar case went before, for a wind farm, went before the local court, and the local court said no, you have to have, it has to be shut down, it has to be quashed because it doesn't comply with the SCA directive. So wind farms are essentially blocked in Belgium and in the Netherlands, and we have two blocked in Ireland, and we're working very hard to make sure, as the best we can, we block every single one. And as soon as we get blocking the new applications for wind farms onshore, we then move to try and make them take down some of the existing ones. I sense they know they're caught on this. I usually have a good knowledge of what I'll win and what I'll lose. I think they know there's no way out of this. They can't go back and assess and produce wind energy guidelines because we'll sue the pants off them. They can't do it. They haven't the brains to do it. And moreover, the SCA assessment requires the need for the project to be assessed. They have to assess, is it needed? And they can't show that wind farms do any good. And therefore, they're going to have big trouble there, and they're staying away from that. Now, I hope I've explained that reasonably well in 21 minutes. The SCA directive, Article 3.2, and there's an earlier article, it's Article 2 there, I didn't look at it, but it's there. If you read it down, just read it down, you'll see it there. It contains a provision for public participation and the right to take a judicial review and all of that part, and who must participate. They've shoehorned right through that, they've bulldozed right through that, and they just produced the guidelines. We couldn't get them on the main Renewable Energy Action Plan. It's very difficult the way it's lined up, but we got them, they were got on the guidelines to help planners decide what to grant and what to refuse, and how far they're from buildings and everything. Those guidelines in 2006 were not fit for purpose because wind turbines have got a lot bigger since then. The distance is 500 meters, and I mean, I can personally swear up in a court that at that distance it's unbelievable torture living near them. So the point about it is, we have got that now. We have the European Court of Judgment ruling, and it applies specifically to wind farms. So it's tailor-made. It's tailor-made. The next job is to get it done everywhere. And the strategy of our government at the moment, knowing that anyone that has a bit of money is not going to let them away with this, because it is to try and horse them on a few people who are poor, put them on poor areas, and again, money talks. Now let me just explain. If you go to fight this with lawyers, you'll have to come up with the best of 40 grand, 40,000 euros with VAT and all in, and of course the government collects the VAT, and you don't get it back in that way. But if you win this case, which I think is a very strong case, you can't say it's guaranteed. If you win your case, as two groups have won already, your barristers and lawyers get the money from Bord Pleanála. I personally got 2,400 euros from Bord Pleanála myself as a lay litigant and a farmer with cows in cows. So you get your money back. Now, what I'd have loved is an association then, when that money is there in a group, that it goes on to the next group and the next group. That was my ideal. That was shot out of the water by people who didn't support me on that. So if you win on this, you get your money back. And honestly, to me, I can't see how you can lose, though I know it's not easy for people who are on low incomes to come up with this kind of money. Nearly take a mortgage out to take your court case. If you lose, your lawyers will keep it. If you don't get costs, they'll keep it. They'll demand you come up with the money up front. Now, at the moment, because this case is getting more established, I wouldn't thank lawyers to go in on half. Take a lump sum of half, 20,000, and take the risk of winning or losing. That'd be the right way to do it. Maybe that'll come yet, I don't know. Okay, I know of two sets of lawyers that are good, and they're doing the job on this. But I've known other barristers and senior counsels to say this is nonsense. This isn't the case. This 2419 doesn't apply. Well, I can tell you it has already worked in two places abroad in the European Union, and it has already worked in two places in Ireland. But of course they'll say, oh no, we didn't yield on that ground, we yielded on another grounds altogether. Pay no heed to that is my advice. They're stuck. We have them cornered, and it's now a question of me and my colleagues to make sure that any community that have the means to challenge on this do so, not to be put off by all the hype and all the baloney and frustrate the whole thing, frustrate it all. And as soon as we get it and I get in the way to work, then I will come out with the boxing gloves on and I will insist on them taking these down. Meanwhile, any investor that invests in Irish wind farms is a fool, because they can be made be brought down. There is no way out of this. It's just a matter of organising it. And hopefully, if I have the health, and touch wood, if I'm around for another while, I will not let up on this. I will not rest till I pull down every wind farm in the country. And that includes Derrybrine, which incidentally was featuring on the news the other day, where Michael McDowell, a former politician and lawmaker, said that they should be left there, when in fact they're in breach of the law. And another girl there that studies this in university said no, it must be assessed. So that's the EIA. Derrybrine's the EIA. We're talking here about the overarching programme and the wind energy guidelines 2006. Before I leave, you go into Curio, search Court CJEU, Court of Justice of the EU. You go into it, you see search a case, you go into C24 //19, 2419, and you click into it, and you'll see the names of the people in Belgium are very peculiar. They're big, long names. I don't know how they're able to work them. There's no Maguires or Smiths or Red Tommies or Black Johns or anything else, but that's the way they do it. Past it, no heed of that. Just read down a bit, and if you don't want to read it all, just go down to the black writing on the bottom, and you see the 3 points. A, all wind farms granted on the guidelines must be annulled, quashed, no planning permission. All existing wind farms must be taken down if challenged. If they're built since 2006 on those guidelines, they must be quashed, and that means then they have no planning permission, and under Section 160 of the Planning and Development Act, you can take them down. And lastly, what if the lights are going to go out? Well, they can keep them going for a while until you get alternative ways of replacing them, which means very little. You can do it, and that's it. That's the law. That's the law. The state will tell you you need a television license. That's the law. You need this and you need that. That's the law, and we have to try and now to claim it and get it working for us. Folks, that's it. It's a long video. I think I've got it across fairly good. I've explained it to you now. If you want to go off and read case C2419 and go down to the bottom and read it, it's there in black and white, and it relates to wind farms. If you enjoy that, give me a thumbs up or give me a thumbs down, and I'll see you back for something else, and I'll only be putting that sort of stuff on this 50. There'll be nothing else ever on 50. Okay, so that's easy found. If you want to go back to 13, I have one there, and I have 145 I and J. You'll see it there, but my voice is bad. I've explained it to you now. Good enough. Don't forget, there's the case there, 2019, but they don't use the 20 to 20. It's 2419. Bye, and we'll see you back for something else. Thank you.